Hello friends and welcome back. So today we will understand indemnification clauses in data use agreements, why it's important in agreements and practical examples to understand the concept. So without wasting any time, grab a notepad and let's begin. What is indemnification? It is a common term which you will keep on hearing again and again if you are reviewing or managing any contracts. It involves one party agreeing to compensate another for any losses or damages that might arise. Essentially, it's about assigning responsibility for potential problems that could occur during the performance of a contract. For example, if party A and party B are in a contract and party B faces losses due to a third party's claim related to the contract, party A might agree to cover those losses. Let's take a real life example. Imagine you and your friend agree to build a tree house. An indemnification clause is like saying, if someone gets hurt because of something I do while building, I'll take responsibility. In contracts, it's similar. It assigns responsibility for unexpected problems that might harm someone outside the agreement, a third party. Usually a third party is individuals whose data is compromised, right? Indemnification in data use agreements. Indemnification clauses are crucial in data use agreements, particularly concerning sensitive data like PII, PHI, or SPI. I have discussed more in details about type of sensitive information along with some examples. You can go and watch that video for better understanding. Indemnification clauses are important in data use agreements which concern PII or PHI, and these agreements often involve multiple parties, including non-signatories with an interest in the data, like individuals whose data is used, right? For example, suppose a healthcare institution shares medical research data with a pharmaceutical company for analysis. In this case, the indemnification clause is important. If the pharmaceutical company accidentally discloses the sensitive patient information, the indemnification clause would stipulate that the company, not the healthcare institution, is liable for any resulting damages or legal repercussions. This clause helps protect the healthcare institution from bearing responsibility for breaches or mishandling of the data by the recipient party. I hope with this example you have understood why this clause is important in agreements, right? Who indemnifies whom? This clause will say who pays who if there is a problem. As we all know that the primary goal of an indemnification clause in any agreement is to outline who is responsible for any losses or damages that might affect these third parties. Third parties are the individuals whose data is compromised, right? The patients. It can be one-sided, where one party shoulders all the blame, or mutual, where both parties share responsibility depending on the situation. Now let's look at a sample data processing agreement which you can also find on internet. It is for Diebold. You can also refer to it for better understanding about indemnification clauses in agreements. Suppose this agreement is executed between Diebold and your company, then let's look at the indemnification clause in the agreement. Now, if you look at here, this clause essentially outlines the responsibilities of your company against various risks in the data processing agreement. This clause states that the vendor agrees to indemnify the company, its affiliates, officers, directors, and employees for any losses, expenses, or cost, including legal fees or attorney fees arising from any events. Defend the company in court if there is a legal claim related to these events, right? Hold harmless the company, meaning the company won't be held responsible for any legal or financial obligations arising from these events. You can pause this video and read this clause. This clause says that the vendor is financially responsible meaning that if you are entering into agreement with default, then you are responsible for any legal or financial trouble caused by your mishandling of the company's data, right? And this could include things like paying fines, legal costs, or financial losses caused due to unauthorized disclosure of customer data. Let's look at some of the key elements of indemnification clauses. Types of losses covered defines scope of what the indemnifying party is responsible for, like what kind of damages or losses are included. Recoverable damages outlines what can be claimed, like legal fees, regulatory fees, or any settlement with affected individuals. And exceptions. It lists any exclusions to the indemnification. There are situations where the indemnification clause might not apply. For example, a common exception is for acts of God, unforeseen natural disasters, or events beyond either party's reasonable control, right? So why these clauses are important? Indemnification clauses help prevent confusion and lawsuits by setting clear expectations. They ensure everyone involved knows who is responsible if something goes wrong with the data, right? So next time, if you come across an indemnification clause, don't skip it. It might seem complicated, but it's a crucial part of protecting yourself and others when dealing with sensitive information. I hope this helps. Remember, this is not a legal advice, and if you have any questions about a specific agreement, always consult with a lawyer. Don't forget to like and subscribe. See you soon with another topic, another video. Till then, take care. Bye-bye.